my name is Ian Scott, and I am the managing partner at Scott Legal PC, and we are a full-service immigration law firm. And today we are going to talk about visa options when someone wants to move from a non-immigrant visa in the United States, like a TN or an O1 or an H1B, or an E2, to a green card, a legal to be a legal permanent resident. So we're going to go through a number of these different visa options in the United States and talk about them. So a few housekeeping items before we get started. So we will record this webinar and we will post the webinar on our YouTube channel. So we do encourage you to go there if you miss anything, and to subscribe also, because we do regularly process webinars. And in fact, this particular webinar will be touching on a number of different green card options, but we will not be going into them in detail. However, we do offer webinars on each and every one of these green card, like separate webinars on each and every one of these green card options that we are going to go through. So you can, if you're live on the webinar, you can, later you can go to the YouTube channel, and if you're watching this on YouTube, you can also go to our Scott Legal YouTube page, and you can see a number of different webinars on a number of different topics also. To the extent you have any questions, you can put those questions into the chat or Q&A box, and we will get to all questions and answer them. And the final thing is, at the end of the webinar, we will send you a number of different things. We'll send you this PowerPoint presentation that we will go through, and we will also send you some guides, the guides that relate to the visas that we will talk about. And also we will send you a link where you can set up a consultation with us if you wanted any further information on any of these visa topics. So let's jump right into it then. So before we get into specifics, I do want to just talk a little bit about the green card system in the United States, because it is a little different from other countries. So in the United States, we have a green card system where unlike other countries where they have a points-based system, they have a green card system where they're just a list of green card categories, and if you're eligible for that particular green card, you can apply for it. Like a lot of other countries have what we call a points-based system, where people might get points for different things, like points for speaking the language, points for education level, age, work experience, etc., and also points for maybe how long they've already been lawfully been in the country. But the US system doesn't do that at all. They just have categories, green card categories, and if you're eligible for them, you can apply, and none of these categories have anything to do with a visa that you may have had before that. So because of that as well, none of the visas that that we're going to talk about that people move from to a green card, none of them lead to a green card, right? There is that concept doesn't really exist in the United States. It's just you may have a non-immigrant visa, like the ones we talked about, TN, E2, O1, etc., and then you may apply for another category, which is a green card, if you're eligible. And then sometimes what ends up happening is the non-immigrant visa categories are similar to the green card categories. It's just the green card categories, often you have to do more. So generally speaking, the green cards are broken up into two categories: family-based and employment-based. There are some others, but these are the main ones. And under family-based, we see that they're further broken down into immediate relative and preference-based categories, and we'll talk about that a little bit more. But immediate relatives do give you some certain benefits, and that's a defined term, which we'll talk about in the next slide. And then the employment-based green cards based on EB1 through EB5. And the only one we're not going to talk about today is EB4. It's a religious-based green cards, and we don't do those at all. But that is a green card category that could be available. But we focus on EB1, EB2, EB3, and EB5. So we will touch on all of those throughout the presentation. So first, let's talk about the family-based green card. So immediate relatives is a defined term in immigration law. So it's not what you would just think of as an immediate relative. So for example, a sibling wouldn't be considered under the immediate relative category. They'd be under the preference-based category. So immediate relatives are, if you are a U.S. citizen that's marrying someone, that's an immediate relative. Or if you're a U.S. citizen child over 21 and you're sponsoring your parents, that's an immediate relative. So the benefit of being an immediate relative is that those categories are always what are called current. So they're never backlogged, because the other thing with the green card system in the US, for most categories, there are only a certain number of green cards that can be issued each year. And then once that is used up, the rest of the people go on a waiting list. So for example, one of the preference-based categories is U.S. citizen sponsoring their sibling, and that particular preference-based category is backlogged by about 14 years. So the sibling wouldn't be able to get a green card for that long, because there are lots of people on the wait list that are trying to get that, would make it so that it would not be possible for that to occur for 14 or so years. So those backlogs apply again across the board, even in the employment-based category. So when we talk about the employment-based categories, it's the exact same thing. When the visa category is not current, it means that the allocation of green cards in that particular year has been used up, and then once the backlog starts, then it can be extended for years, because there are more people that want the green card than there are actually green cards available. And even when the new number is allocated in the new year, they're just used up immediately. So the backlog doesn't move very much. Now, in terms of the green card process, like obtaining a green card, this is going to be the same again across the family-based and the employment-based green card categories. There's always going to be either a two-step process or a three-step process. So if it's a two-step process, then you're going to be filing an application that shows that you have met the requirements. So under a family-based category, if you are marrying a U.S. citizen, you're going to be showing a marriage certificate and proof that the marriage is a legitimate marriage. If you're under the employment-based category, you're going to be showing documentation showing that you've met the criteria, and we'll talk about those criteria more as we go through their different slides. So that's the first step. The second step is going to be either doing consular processing or adjusting status in the US. So consular processing would be if you're outside of the US, or if you're inside the US and you want to get the green card at a consulate. Whereas the adjustment of status would mean that you're in the United States, and then your visa category is current, because you can never apply for consular processing or adjustment of status unless your visa category is current. So you're in the United States, your visa category is current, and then you are applying for an adjustment of status application. Now, the good thing about adjustment of status and when your visa category is current is that you can stay in the United States and get benefit throughout the whole immigration process. So you can file for employment authorization and travel authorization, and what that allows you to do is it allows you to stay in the United States and work, and stay in the United States, and if you left the United States, you'd be able to re-enter. So you do have travel authorization as well when you file the I-485 application. You do have to wait for those to be approved before you could work and before you can actually leave the US. But great benefit, because if you have a category that is taking quite a long time, like I'm going to talk about EB5, and EB5 can take 5 years to be approved. If you're able to file the I-485 petition concurrently with your EB5 petition, then you're able to stay in the United States and live and work through all that period. And again, keep in mind that, and I said it could be a three-step process. So the second step is always going to be applying for the green card. And there are some instances, though, where the third step can be a removal of conditions. So under the immediate relative category, I mentioned that if a U.S. citizen marries someone, that 2 years after the person gets a green card, they have to file another document to remove the conditions on that green card, because the government wants to see after a period of time. And this happens in the employment-based context as well under EB5, where 2 years later another document has to be filed to remove the conditions. So it's either going to always be a two-step process or a three-step process. In terms of family-based, we often have this when people are moving from a visa to a green card. We often have someone's in the US on a TN or an E2, and then they meet someone and they marry, and the person happens to be a US citizen, or they may have a US citizen parent that's in the United States that's able to sponsor them, or they could have a US citizen child that turned 21 and is able to sponsor them for a green card under the immediate relative category. So this, I think people do move to green cards often from visas in this category, and next we'll talk about the employment-based category. So the first, we said the employment-based moved from EB1 through EB5. So the first one that we're going to talk about is EB1. And EB1 is broken out into EB1A, B, and C, but the main two that we see people moving from, to green card to, so the main one we see people moving from visa to green card to is EB1A. Sometimes EB1C as well, but EB1A is the main one. And what this is saying is that you have extraordinary ability and you've risen to the top of your field. And what you'll see is some criteria. There are 8 or 9 criteria that are listed there, and the individual would have to meet at least 3 of them. So let's say that the person was making a high salary compared to other people in the peers, their other peers rather. The government says that if they're making that high salary, that must indicate that they've moved up in their profession. So that's just one criteria. If they're judging the work of others, if you think of, what's American Idol, the judges that they have there are people who have already made it to the top of their profession, and they're judging other people and commenting. And so if you have, if you have that to show the government, then that could indicate that you've risen to the top of your field as well. Now, keep in mind what I said, that this particular this particular category, EB1, we do have separate webinars on this that we go through each, and in those webinars we would go through each and every one of these criteria and talk about them in a lot more detail. But this is just kind of giving you a flavor for what is there. Now, the people who usually move here are people who are on O1s, right? So now there's a non-immigrant visa category. It's called O1. And it's very similar, where you have to meet 3 criteria, and the criteria are pretty similar to the ones that are here, depending on which type of O you're on, but pretty similar to the ones that are here. So this a lot of people that do O1 and then they maybe do a few more things and accomplish more, then they would apply for an EB1A after that. And just to briefly comment on EB1C, that is transfer of a senior manager or executive, and we see people moving typically from L1 to EB1C because the criteria is very similar. But just always remember that the EB categories like EB1, 2, 3, and 5, they are always going to be more, even though on paper, the criteria might look very similar. There is always going to be more that you would have to do for the actual green card. The one great thing about EB1A is that you can self-petition, so you don't need an employer. So that is a great thing. And when we do these even for entrepreneurs, so we might say that the entrepreneur has a startup and they've been selected by incubators, or even judging the work of others, they could be the ones selecting where investment goes or who gets to go into the incubator. So that could be an example of judging the work of others, or if they've made significant progress in their endeavor, and let's say they have some patents and things like that, that might be something that shows that they have evidence of the original scientific or scholarly artistic contribution of major significance in the field. So lots of things that we can do for entrepreneurs there. And again, I said earlier that it's either a 2 or 3-step process. This is going to be a 2-step process. Instead of filing an I-130, which you'd file in the family-based case, you would file an I-140 here. And then depending on whether or not you were in the United States or outside of the United States, or some other factors as well, you would file either adjustment of status application, or you would do consular processing. So something to keep in mind. And again, though, the category has to be current before you do that. And I believe that right now the category is current for all countries except for India and China, EB1, that is. So the next one we're going to talk about is, we move a lot of people to EB2, national interest waiver, from many different types of visas, and E2, H1B. So, a number of different types of visas we move people to from a visa to a green card. And what this one's based on, it's based on a case called Danisar, and you have to prove 3 things. So the first thing you have to prove is whatever you're coming to the United States to do, that's of national importance, right? So that's the first thing that you have to prove. The second thing that you have to prove is that you're well positioned to advance the endeavor. And the third is that on balance, that the government should waive the labor certification. Now, when you're looking at the proposed endeavor being of national importance, that could be job creation. It could be looking at your company and what your company or entity or what you are actually planning on doing, and just looking to see, does the government talk about this? Do they have pronouncements in the media? Do they have statements indicating that they feel that this is important to the nation? And why? So this is something that that you can get expert letters on as well, like experts that say that yes, the government feels this is important, or it is important because of X, Y, and Z. So that could be very helpful. And then and as I said, there's a separate webinar on this, and there's a lot of strategy that goes into doing an EB2 national interest waiver petition, and really good to sit down with the immigration attorney. But the very first thing that we are focused on with national interest waivers is obtaining the endeavor. Like, what is it that the person's coming to the U.S. to do? Now, that can be a job, but it can also be their own endeavor. And this particular category, you can also self-petition for it. So that's a great, you don't need an employer necessarily to petition for you. Now, one thing to keep in mind with this category, and this is something that a question that we get often, people, they look at these threshold considerations and they think, oh, I met the threshold consideration, I'm eligible, I have a master's degree, or I have a bachelor's plus 5 years, or I have exceptional ability. And the exceptional ability is different from the extraordinary ability that we talked about earlier. But these are just threshold criteria for EB2. So EB2, when we're going to talk more about EB2 in a second, but EB2 is broken out into two areas: national interest waiver and also a company that's just sponsoring you for a green card. And to be eligible for EB2, you have to have either an advanced degree, so it's master's degree or higher, or a bachelor's plus 5, or a bachelor's degree plus 5 years of experience, or exceptional ability. And exceptional ability is 7 criteria, and you have to meet 3 of them. And it's a lot lighter, than the criteria under extraordinary ability. Like, for example, one of the criteria might just be having a degree, right? So someone that had a high school could maybe qualify under exceptional ability, or someone who had a bachelor's but didn't have actually 5 years of experience could still qualify under exceptional ability. But that just means that they're able to a threshold issue. So now they're able to move forward with assessing the DANISAR criteria. So that's the process here is the same, where you file an I-140 and then an I-485 or consular processing, depending on whether you are, depending on whether you are in the United States or out. And again, the lots of visas, we move people from lots of different visas to this. I'd say the primary one, though, would be people on E2 visas, and we can argue job creation, and we can argue other things, like typically depending on what their business is doing, we can argue that that's a benefit to the nation as well. So all of those things can be important. The next one we're going to talk about is a company sponsoring you for a green card. So that's going to be under EB2 or EB3, and it's called PERM. So this particular process is a combination of work between the immigration officials and the Department of Labor. So the company sponsoring you, and it's a 3-step process where you're first dealing with the Department of Labor and getting them to tell you how much the job should be paying, the prevailing wage. We started with the job description. And then once that is done and you have an approval from the Department of Labor, then you're able to file the I-140 petition and the I-485 petition. Now, what ends up happening here is that we have situations where the spouse sometimes gets a job with an employer, and then the employer will sponsor them. But also, I'd say this is probably a category where we move most people to green cards, because it could be someone working as a TN or H-1B that's working for a company, and then the company decides to sponsor them for a green card. So I think this is a key way that people get sponsored. It is a long process, because the government, what they're trying to do is prove that the company rather is trying to prove that they can't find another qualified U.S. worker, right? So that's what the whole process goes through. So they're actually doing job postings, interviewing people, going through a full recruitment process, and seeing if anyone who applies, can they exclude that person, right? Like that's the whole process that they're going to, can they exclude that person? And So yeah, so it's definitely a significant way, and it's going to be the same thing where you're filing an I-140 and an I-485. And again, though, you have to kind of keep in mind that the category has to be current in order to file the I-485. And right now, EB2 and EB3 are not current for any country. So that's, you know, something that's going to be important in your decision making. Which just means you have to wait, right? So, but then the wait isn't at like 14 years, like the sibling category, but there could be a year or two wait. So you would have to maintain underlying status during that time. So the next one we're going to talk about is EB5. So EB5 is a green card that you can get for investing either 800,000 or 1,050,000 in a business. So it can be a new business, but also new commercial enterprise just means a business that was formed after 1990. So you would the reason the two numbers are different if you're investing in where the business is in a targeted employment area, so a business where the unemployment rate is 1.5 times the national average, or a rural area, then the amount you're going to invest is 800, and if higher than 1,050,000, then if it's not a TA, then 1,050,000, and you can include a lot. We get a lot of people. We move from E2 to EB5 because E2 is an investor-based visa. So I'd say that's the primary way people move to EB5. But also on other visas, people move to EB5 because they invest in what's called a regional center. So they give someone else who is maybe building a hotel or something, they give them 800,000. So that they can, the someone else has to worry about managing that. As I said, we move a lot of people from E2 to EB5. There are differences, though. The source of funds analysis for EB5 is quite significant. EB5 doesn't really permit you to purchase a business, whereas E2 does. So a lot of differences here. And the other big part of EB5 is that you have to create jobs. You have to create 10 full-time jobs, and those have to be U.S. citizens or green card holders. So that's another big thing to consider. And then if you are doing a direct investment EB5, because we have direct investment where it's your company or you're investing in a company, and then regional center where the investment is much more passive in nature. And then the other thing just to keep in mind is that the money that you invest does have to be linked to job creation. So that's something to keep in mind, that it does have to be linked to job creation. Now, the EB5 is going to be similar in the sense that there's going to be it's going to be a three-step process where the application that you file, similar to the I-130 or the I-140, is an I-526 application, or an I-526E if you're doing a regional center. And then once you file that, as long as your category is current, you can also file the I-485 and or do consular processing. With consular processing, you would do once the I-526, can only do once the I-526 has been approved. But if you're in the United States, you can concurrently file an I-485 application, which again gives you the benefit of being able to apply for work authorization and travel authorization. And then 2 years after you get the green card, you have to file an I-829 application. And that application is one that you do to remove the condition. So saying that you actually have created the 10 full-time jobs that you said that you were going to create. So a few other green card options just to keep your eye on: the diversity lottery. So that's something that comes up in October rather. So it's coming up in October, and then they select the people in May. So the selection of the people is coming up, and that's they give away 50 or something thousand green cards every year. So definitely take a look at the requirements for that in October and apply online. You can apply on your own. You don't really need a lawyer to do that. It's quite straightforward application process. Sometimes people hire lawyers after they get selected, if they get selected. There are also humanitarian-based green cards that you can consider if you're, whether it's asylum, whether it's if you've witnessed a crime and helped the police, if you're a victim of domestic violence, all of those, there could be green cards that could come out of that. And then, of course, we're, hoping for immigration reform to kind of bring about some positive change with respect to the system. things to always consider is timing considerations. The EB5, for example, takes around 5 years to be approved. So you want to make sure that you have underlying status and or filed an I-485, so you're able to maintain status in the United States. So because of it, and you also have to keep a look at these quotas, like the backlogs that we talked about before. And if you're in the United States, make sure that you're, know when you can travel and when you can, like if you have an I-485 application pending. The other thing to consider is that, we talked about lots of different non-immigrant visas, TN, H-1B, E2. Some are dual intent and some are not, like E2 and TN are not, whereas O1 and H-1B are. So if you have dual intent visa, then you can have a lot more flexibility with respect to coming and going and your ability to say whether or not you plan on adjusting status in the United States. So it sometimes can be complex to navigate all this. And we do sometimes have people filing multiple green cards. We have someone that was this came up just the other day, where the person has an approved EB5 petition, but now she looks like she's going to marry a US citizen. And it actually would be much more beneficial for her to get the green card through marrying the US citizen, even though she already has an approved EB5 case, because the EB5, remember I said after 2 years after she gets the green card, she has to remove conditions. So she'll be in this green card system for many years, many years after. So really planning is the key thing, I think, that we you have to do. So let me just so we do have one question, and I'm just going to pull it to the screen because it's anonymous, so that's fine. So let's see. Could a person who originally applied for and was approved for a green card for consular processing in Montreal later change and request adjustment of status in the United States when the category becomes current if they moved to the US on a TN visa while pending current status, if they are living in the US on a TN when their category becomes current instead of going to Montreal? So the answer is yes. So if you're in the United States and you now have changed your mind with respect to whether you want to adjust status, there is a process for changing and then just adjusting status and notifying the consulate that you'll no longer be going through adjustment of status. Sorry, going through consular processing. Any thoughts on whether the new U.S. president in November might implement new immigration regulations? Well, I mean, any patterns from past new presidents you can share? Well, I think that I think we have a good indication of what the immigration policies are from both of the people who are running for office in the United States in 2024. So I think that the immigration policies and kind of what you can expect for immigration, I think is going to be consistent, I think, with what the last administration did and what this administration did. So definitely just a question on cost. How much does it cost to process for EB2? So EB2 is either EB2 national interest waiver or EB2 sponsoring for a green card. But if you send us an email, we have detailed fee summaries that we can just send you, because the fees are broken out into what someone needs. So for example, someone may not need work authorization, travel authorization because they're doing consular processing, or they maybe just don't need it. So the fees are kind of different depending on that. When the child turns 21, does the child have to reside in the U.S. in order to sponsor his or her parents? Yes. So yes. So if the child is, it's a great question, because it's the whole basis for having the immediate relative category, or any category really, family-based category sponsor, is family reunification. So the child doesn't have to be living there when they sponsor, but they have to say that they plan on going back, or making an affirmative attestation that they plan on going back to be in the United States. So but that is a question that often does come up. Excellent. So I think that is it for the questions. I think that's it for the questions. And thank you again very much for attending the webinar. And as I said, we will send a copy of the the PowerPoint presentation and the webinar to everyone through email, and some of the guides as well, and information how you can set up a consultation, but also information on how you can see other webinars that will give you more detail related to some of the things that we've talked about today. Thank you very much.